supremacy of the Constitution, and the unalienable right to bear arms. A legal argument against all gun laws. The United States Constitution, as the supreme law of the land under Article Physique Clause 2, establishes that this Constitution shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. This supremacy clause mandates that all federal, state, and local laws must conform to the Constitution's text as written and ratified. The Second Amendment, part of the Bill of Rights ratified in 1791, declares a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This language is absolute and unqualified, prohibiting any infringement on the people's right to arms. When read in conjunction with the foundational principles of natural rights articulated in the Declaration of Independence, that individuals are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. The right to bear arms emerges as a God-given, pre-political entitlement rooted in self-defense and resistance to tyranny. No government, federal, state, or otherwise, possesses the authority to strip this right, as it precedes and transcends governmental power. Furthermore, no subsequent amendment to the Constitution has modified or qualified the Second Amendment to permit infringements, rendering all gun laws unconstitutional and void ab initio. This argument is substantiated through textual, historical, philosophical, and jurisprudential lenses. 1. Textual supremacy. The absolute prohibition on infringement, the Second Amendment's command that the right shall not be infringed, is imperative and categorical, admitting no exceptions or qualifications within its text, unlike other amendments that include limiting clauses. E.g., the First Amendment's prohibition on laws, abridging speech, which courts have interpreted with some flexibility. The Second employs infringed, a term historically meaning any encroachment or diminution. As the Constitution is supreme, any law that imposes conditions, restrictions, or prohibitions on the keeping and bearing of arms, such as licensing requirements, background checks, bans on certain firearms, waiting periods, or registration, directly contravenes this mandate and is nullified under Article Vixi. The absence of any textual carve-outs for public safety, felons, or mental health underscores that the framers intended an unyielding protection. If the right could be regulated away, the phrase "shall not be infringed" would be rendered superfluous, violating canons of constitutional interpretation that required giving effect to every word. No amendment has altered this absolute language. The Constitution's amendment process under Article V requires explicit changes via ratification, yet none of the 27 amendments addresses or dilutes the Second Amendment. For instance, the 14th Amendment incorporated fundamental rights against the states but did not authorize new restrictions on arms. Absent such an amendment, legislatures and courts cannot imply exceptions. To do so would usurp the people's sovereign power to amend the Constitution. Thus, all gun laws, from the National Firearms Act of 1934 to modern assault weapon bans, are ultra-vires and illegal, as they infringe without constitutional authorization. 2. Philosophical foundation. The God-given right to self-defense, the right to bear arms, is not a governmental grant, but a God-given natural right inherent to human dignity and survival, as recognized by the founders. The Declaration of Independence affirms that rights are endowed by their Creator, placing them beyond governmental reach. This includes the right to life, which necessitates self-defense against threats, whether from criminals, invaders, or tyrannical rulers. John Locke, whose philosophy influenced the founders, articulated this as the fundamental law of nature, where one has a right to destroy that which threatens me with destruction. Alexander Hamilton echoed this in the Federalist Note 28, calling self-defense the original right paramount to all positive forms of government.
Biblical precedents further substantiate this as a divine entitlement. Exodus 22:2 permits lethal force and self-defense without guilt, while Luke 22:36 records Jesus instructing disciples to acquire swords for protection. Colonial pastors like Rev. Simeon Howard and Rev. Samuel Stillman viewed self-defense as a law of nature, revealed in Scripture, obliging individuals to protect themselves and others. As a God-given right, it is unalienable, irrevocable by human authority.
Governments exist to secure these rights, not to abridge them. Any law stripping arms from individuals, even under pretext like domestic violence restraining orders or felony convictions, violates this principle, as no government can revoke what God has bestowed. 3 historical context. Founders' intent against any restrictions. Originalist interpretation confirms the founders' envision no governmental power to infringe on arms. Drawing from English traditions like the 1689 Bill of Rights, which affirmed arms for defense, colonial Americans rejected disarmament attempts, as seen in British efforts at Lexington and Concord. State constitutions, such as Pennsylvania's 1770 Declaration that the people have a right to bear arms for the defense of themselves and the state, reflected this. Anti-federalists like Richard Henry Lee and George Mason insisted on explicit protections, warning that disarming citizens enables enslavement. Noah Webster argued an armed populace prevents unjust laws enforced by the sword, while James Madison noted in Federalist No. 46 that governments fear trusting armed people. The Second Amendment's ratification debates show no intent for restrictions. Instead, it was to ensure Congress shall make no law infringing this right. The parallels for modern gun laws are absent, as required by New York State Rifle and Pistol Ass and V. Brune. 2022, which demands consistency with tradition, yet no tradition supports broad infringements. Disarmament historically preceded tyrannies and genocides, e.g. in Nazi Germany or Soviet Russia, underscoring why the founders barred it. 4 jurisprudential implications. All gun laws are illegal absent. Amendment Supreme Court precedents, when faithfully applied, support this absolutism. District of Columbia v. Heller recognized an individual right unconnected to militia service essential to resist tyranny. However, dicta in Heller suggesting long-standing prohibitions are permissible deviates from text and history. Such exceptions lack constitutional basis and represent judicial overreach. Brune further invalidated subjective restrictions, but to be consistent, all infringements must fall. Since no amendment authorizes gun laws, they violate the Supremacy Clause. As Justice Hugo Black noted in other contexts, rights are not subject to balancing tests. They are absolute. Governments cannot condition God-given rights on permits or checks, reducing them to privileges. All such laws are illegal, and citizens have a duty to resist them peacefully through nullification or amendment pursuits, preserving the Republic. In conclusion, the Constitution's supremacy, the Second Amendment's absolute text, and the unalienable nature of God-given self-defense rights render all gun laws unconstitutional. No government can strip this right without amending the Constitution, a process that has never occurred for this purpose. This argument upholds the founders' vision. An armed citizenry is the ultimate guardian of liberty.